It is June 2nd of 2026, and this is the Court Gallery. When you go to court, there are a few simple rules. Be respectful, be on time, and maybe don't represent yourself if you think civil court rules apply to your criminal case. In this session, one man learns that a judge in one county can't overturn rulings of a judge in another. Later, a defendant on probation thinks he can lie to the court about getting permission to travel, but he forgets one crucial thing. The judge has the receipts. And we'll end with a small claims plaintiff who decides the best strategy is to argue with the judge about procedure before the trial has even begun. Today we'll see all this and more, and it all starts right now.
Good morning. Come on up, Mr. Blake. Settle in. All right. Ms. Caitlin Foley, your appearance for the township. Thank you. Good morning, Mr. Blades. You don't have to jump up. They train on law school to jump up. All right. So before we get to all the jurors here, and I guess they're coming in, I don't know how many we've got, but I wanted to take care of some pre-trial stuff. So you brought a bunch of paperwork in 2 weeks ago or so? Okay. Most of that I couldn't figure out if you were asking for something, if you just submitted that for the court to have it. The one thing that looked like an ask was you filed a motion basically attacking the Monroe County conviction again. Would you agree?
Yes, I put that in there.
Okay. Well, we argued that out once, and I told you that whether or not Monroe messed up, I could not overturn what happened at the Monroe District Court. You'd either have to go back to the District Court or the Circuit Court in Monroe County. Remember that? We argued that motion once? All right. Is there anything else that you want to deal with out of those filings or anything else prior to getting the jury in? I can't hear you. Yeah, pull it in. Okay. So you filed a stack of documents a couple weeks ago. Okay. I want to know if there's any of that you want to deal with now, because we're not going to argue motions in front of the jury.
Okay.
Okay. All right. So none of that filing is something you wanted to deal with before the trial. Okay. So you're planning on submitting 240 some pages worth of evidence today? Okay. Understand that all of that's subject to an objection from her if it's not relevant. Okay. All right. And I'm going to tell you right now, all of that stuff from Monroe is not relevant.
Talking about the record.
I'm sorry. The record. The driver. Well, the driving, I'm assuming the people will plan on introducing your driving record. Okay. All right. Okay. So do you have any other pre-trial questions?
Just want to be able to submit the evidence to the jury.
Okay. Well, I don't know if you will or not, because as you submit something for evidence, we'll have a discussion about whether or not it's relevant, whether or not it's probative versus prejudicial, all those things through the court rules. Understood?
No, where these ready, excuse.
That's all right. Take your time.
It's already on the validity of the judge. Validity of the judge.
But it doesn't. And I explained that to you when you filed that motion. The Secretary of State, hold on, let me talk. The date of this arrest, if she can prove, she being the prosecutor, if she can prove that on the day of this stop, your license was suspended from the Secretary of State, the fact that it was improperly suspended by Monroe County doesn't change the fact that the officer had paperwork that said you were suspended from Secretary of State. That's why I told you months ago, you have to attack that judgment in Monroe if you think it's inappropriate.
He was what?
and I told you, I can't, oh,
Never actually. To overturn, just to recognize the jurisdictional effects. We are,
but hold on. It doesn't matter if I recognize something. Sir, don't interrupt me. Don't interrupt me. It doesn't matter even if I agree with you that Monroe did something wrong, there's still a valid suspension from the Secretary of State. But you have to deal, but you can't deal with that here. Well, whether or not you can make that argument to them is based on the discussion we have. You want to have that discussion now, we can have it. Well, no. You're not going to present anything to the jury until I tell you you can't. That's the way it works. So let's argue that right now. You want to present your theory of the Monroe case. Interrupt me one more time, sir. We're going to have a long day today. Interrupt me again, and I'm going to hold you in contempt. You understand that? If you want to present to the jury what you claim was wrong in Monroe that led to an improper judgment that went to a Secretary of State suspension, if you want to argue that to the jury, we'll discuss whether or not that should be in front of the jury today, right now. Is that your argument? Okay. All right. Is there anything else you want to? I tried to put in my words what you're trying to do. Do you want to put it in your own words so I can give Madam Prosecutor a chance to respond? Okay. Madam Prosecutor. Okay, well, that's too vague. That's too vague. That's too vague. Once again, yes or no? You want to talk about what you think was wrong in Monroe to this jury today?
No, I want to talk about the record and how it got there to the jury today.
And how are you, and what is that going to be?
That's going to be the laws of the four rules. The four rules, that's all I plan to present, four rules, and the judgments that are based upon the four rules.
Doesn't that get you to a discussion about Monroe County?
It all starts with the record. It all depends on how the record got there. What was that? Because prosecutor and according to your state you just made is your record. What he saw when he pulled me over is what he went by when he arrested. Okay.
Well, I can guarantee that's going to be part of the case because this is a drove while license suspended charge. My
To be authenticated as to why it is there.
I disagree with you, sir. I disagree with you, sir. What the prosecutor's going to have to present today is a certified record from Secretary of State that shows you were suspended. There's nothing that says we have to get into why you were suspended or how you were suspended. What court rules are you referring to?
That's your 2.105.
What's that say?
Individual. Process may be served on a resident or non-resident individual by delivering a summons and a copy of the complaint to the defendant.
All right, Mr. Blade, let me stop you. That court rule is about civil cases, like if you're not paying your credit card bill. That's for civil cases, not for drove while license suspended charges. Not for criminal cases. It most certainly is. It's a 93-day misdemeanor. Drove while license suspended, revoked, or denied. That's the top charge on your file. It's a criminal case.
It can be a criminal charge, but
Sir, trust me when I tell you, I can put you in jail on this charge. By definition, that means it's a criminal charge. So we're not talking about civil court rules. It's irrelevant. Because that court rule 2.105 is regarding civil process, not criminal. I told you when you said you wanted to have a jury trial by yourself, you were in over your head. We're not talking about 2.105 today. Not in front of the jury.
How about this move forward from the page?
I'm sorry, what? I don't understand what a containment is. Continuance? Absolutely denied. The jury's coming in today for a jury trial. We gave you a scheduling order that gave you plenty of time to file any pretrial motions. I gave you grace today when I talked about what you've brought in 2 weeks ago, because that was a day late. So absolutely no, you are not getting a continuance today. If you want to take 2 or 3 minutes and talk to the prosecutor about seeing if there's any offer, that's fine. Otherwise, we're going to a jury trial without an attorney, because that was your choice, with all 3 charges.
We're not discussing the prosecutor, please.
I'm sorry, was that a yes to discussion?
Yeah.
Okay. All right. Take a few minutes, not a lot, because as soon as I've got enough jurors, I want to get them started if we're going to work them. Remind me, come on up, have a seat. Yeah. Remind me, I'll give you some feedback from the users down there. Yeah. It's new. I'll say that. Yeah. Ms. Caitlin Foley, did you have conversation?
Yeah, we need to go to resolution for your child.
Okay. What is it?
Notable license suspended, you will be dispensing the operating of correction vehicle as well as the unlawful use of license plate.
Okay. Mr. Blades, correct? You understand your rights and the options those rights present? You understand the possible penalty of the charge is up to 93 days in jail, up to $500 fines plus court costs? And that's the deal you want to make today? Did you drive a vehicle in Huron Township on November 29, 25? At the time, was your license showing as suspended, revoked, or denied from Secretary of State's records? Are you satisfied with the plea? I'll accept the plea to count 1, dismiss counts 2 and 3. Mr. Blades, let's talk about your financial situation. Are you working? Yes? Where do you work? I'm sorry, say it again. Bomar? Comar. Where are they at and what do they do? Okay, how long have you been with the company? Full-time job? Full-time job? And, all right, anything else you want me to consider before I sentence you? Yeah, lean up, yeah.
What do you find? Don't say no to my friend.
Tell me about it. In a word? Go ahead. Okay.
Scared. I have bills, I have friends, I have children, but I don't have a lot of playtime. I have to get back and forth to work. So that really has this.
Give me an idea. What kind of shift are you on? What kind of schedule? 2 p.m. to 10 p.m.? How many hours a week you're working? Okay, well, what's a minimum in a week? I mean, like 35, 40 every week, or it could be 0 to 40?
I get regular work days. For how many hours I'm working.
Okay. All right. So let me ask you this. Well, let me tell you this. We've got other files in this building. One of them goes back to 10 years old, 2016. Currently, you owe us over $3,000. I don't see any attempts to make any payments on these. Okay. All right. So yeah, well, I'm not gonna pay a clerk to process $1 payment. I mean, that's a net loss to the building. So I've got some options. Well, first of all, let's talk about the old money before we talk about today's file. On the $3,000, yeah, you guys don't have to stick around for this if you don't want to. For the $3,000, I can send you down and we can put you on the work program. Unfortunately, that means you got to be out here because we do the work. We don't do the work program in Monroe. I can give you work days, which means you pick the days. The days you pick, you have to be here at 8 o'clock in the morning to go out with the crew. Or I can give you some community service hours, which means you work with a charity, nonprofit registered with the IRS. You can work off our list, or you can find someplace closer to Monroe County or, closer to home. But it's got to be an IRS registered nonprofit organization. You have to do X number of hours, document it on their official letterhead so we can confirm it with them and document that or present that to the court. So those are options how we can pay off that $3,000. All right. So I'm going to send you downstairs on the $3,000. I'm going to send you downstairs to talk options. All right. So on today's file, normally I sentence $500 on this. So I'll do, let's see, 4 days. What is today? Early. July 10th. All right. So on today's file, it's $500 or 4 days on the work program or 30 hours community service. One of those three has to be done between now and July 10th on today's file. You understand that? You want to do work program? Set that up downstairs. All right. And as far as the 3,000, they'll talk about your options down there, whether or not you want to do work days, charity hours, some combination, they'll work something out. Understand that work program days are assessed as an alternative to jail. That means if we give you a schedule, we expect you to be here, because if we give you that seat, we can't give it to somebody else. All right. So if we give you a schedule and you don't show up for one of those days, we'll give you, hold on, we'll give you a reschedule once. After that, you're probably doing the jail days. I can't hear you. The work program isn't, I just said that. Work program is done here. You have to, if you pick work program, you got to be here at 8 o'clock in the morning. I can't do it in Monroe County. My work program runs my 5 communities. I don't send a crew to Monroe County. The charity hours you can do in Monroe, but those aren't 4 days. Those are hours. Charity is hours. Work program is days, just like jail is days. So if you want to do the charity, go downstairs and talk about that.
The charity, that's what.
So on today's file, that means 30 hours between now and July 10th, documented by July 10th. Clear? Okay. Go on downstairs. Yeah, you can bring them. Yeah, please. So Lisa, it's so screwed up down there because the court users didn't have much input. So for example, they had electrical outlets in the jail cells. They had porcelain toilets in the jail cells. The jurors in the circuit court, they seat 14 because a felony jury is 12 plus they have 2 alternates. So they seat 14. When they put them in the jury deliberation room, there's 1 toilet available.
Lucas Barnes was the first person to check in. Would you come forward, please? Good morning, sir.
Morning.
We got a number of these today. It's Three Rivers. You got a ticket for being a disorderly person.
Yes, sir.
They wrote that under Three Rivers ordinance. Disorderly person is a misdemeanor under Three Rivers ordinance. It's punishable by up to 90 days in jail and a fine of up to $500. This says it happened at 3:30 in the afternoon on May 17th. Thanks. May 17th was a Sunday at your house at Pearson Street. Pearson Street's not a very long street. That's where Mike King lives.
Yes, sir.
Anyway, that's the allegation. How do you plead to that charge?
I'm guilty.
All right. Anybody threaten you to get you to plead to this?
No, sir.
Or promise you anything?
No, sir.
What happened?
There was an incident quite some time ago where my neighbor's dogs hit my wife. And honestly, I should have addressed it at that time with the proper avenues. I let that turn into a situation where we had some animosity. We've had some back and forths, and I realized I was in the wrong. I should have got the proper avenues involved, and I didn't. So moving forward.
So you ended up yelling at your neighbor out in the street?
Yes, sir.
Who's your neighbor?
Amber.
Oh, she got the same ticket.
What's that?
She got the same ticket, I think.
I'm not clear on that.
She isn't here. All right. Well, I appreciate your willingness to accept responsibility. Sometimes the best thing to do is just get it over with. I'll accept your plea. I'm going to reduce the fine a little bit. This is ordinance. What do you do, sir?
What's that?
What's your occupation? I don't know.
I was in management of cargo trailer manufacturing, but the company closed. So I've been out of work for a little bit. I've done basically all trailer manufacturing of all sorts.
Well, I'm correct. That's a little short street there. Not many people live on Pearson Street.
Yes,
Your
yes, sir. Yep.
houses are close together. $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. Amber Carpenter got the same ticket you did. What? Oh, she's running late. All right. Anyway, can you pay that $200 today, or do you need time to pay it?
You can pay it.
Very good. All right. Like I said, sometimes the best thing to do is just get it over with. Although these neighborhood disputes can be difficult, especially when you're stuck next to each other. All right. Thank you, Mr. Barnes. I don't think you have any unpaid fines or anything. So the court officer will take you out. You can pay that fine, and I hope things quiet down over the summer. Thanks. All right. Good luck, sir.
Thank you.
Let's keep going here. William Lowry. Mr. Lowry, I thought you weren't going to come back here anymore.
Well, I mean, like, there's so much, I don't want to.
You like the room?
It is, but better, I like it a lot better, actually.
Thanks. This is file 26728OT. This is an ordinance case. Mr. George isn't here.
Judge, Village of Centerville.
Oh, Centerville case. All right, thank you. Mr. Nossinger is here. Yes, you got a ticket on April 16th for driving suspended right here in Centerville. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You have $675 worth of unpaid fines and costs. the last time this year you got a driving suspended, they reduced it to allowing another to make the motor vehicle code. I think you're on a payment plan, but
I do have my license now, Your Honor.
do you have your license now?
Yes, I do.
All right, Luke, would you talk with him at a pretrial?
Yeah, absolutely, Judge. And it looks like there are a couple other cases hanging out there too. I think Mr. Lowry will be back on Friday.
From the fifth.
Friday.
Oh, they're all set for
I could only find one.
attorney pretrial. He's got another DWLS.
Mm-hmm.
Who's your attorney?
I got George Tim for one, and I think,
Casey Strong.
Casey Stone or Stone, whatever for the other one, I believe.
All right. Well, you gotta stop doing this.
Yeah.
You live in
I got
Centerville.
it.
You need to be driving around in Centerville. You have an attorney pretrial set for 6.
Yeah.
For 6. 6/5. 6/6 is a Saturday. I'm just gonna have you come back and we'll deal with this along with everything else. If you'd like to go to jail, you're doing a pretty good job of it. But I just keep making this worse. And not paying the fines you get. I don't know the sense of giving you a fine if you don't pay the old fines. Plus you got a break on the last one, and then you got another one, and then you got another one. I'm gonna give you a notice to appear for Friday. All right, we'll look at all 3 of these cases together. And Luke, are you set to be here Friday anyway?
Yep. No, I'm not, Judge, but I'll make it work. He did flash his license. It looks like it was issued May 1st. So I just want to take a look and verify his driver's history, and ultimately the goal is for him to have a restored driver's license.
Yes, it is. I'll ask him to run new driver's license. All right, Mr. Lowry, I'll see you Friday.
All right. You have a good day, Your Honor. Thank you.
All right, we're working on it. And make some payments on your unpaid stuff. That would help too. Or Myers. Brian Myers. Will you come forward, please? Okay, thanks. What?
Special center.
I'm gonna get
Brian Myers.
MY,
Jameson Hammond. I think I might have sent that file out with some other files. Oh, nope, here he is. Abby will need that one. No shows. Anyway, Mr. Myers, you're late, but that's better than not coming. You had to come all the way from Berrien County. This is 26-710 OT. I found it. I gave it to Paul and he gave it to Abby, so sorry about that. Mr. Spencer's license is still expired. Anyway, Mr. Myers, you got a charge of driving suspended. That's a very common offense. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 2 points on your driving record and requires your license be suspended. So let's take a look at your ticket. You got it at 3 o'clock in the afternoon on Buck Street in South Main in Three Rivers. And you say you were suspended. Let's take a look at your driving record. You failed to appear on May 19th, but you did call.
I was having an issue trying to find a ride here.
Your license is revoked. For a lot of baggage on here. So driving suspended is a misdemeanor, as I said. How do you plead to that charge?
I'm guilty.
Anybody threaten you to get you to plead guilty to that charge?
Sorry, I couldn't.
Anybody threaten you to get you to plead to that?
No, sir.
Or promise you anything?
No.
Now, you don't owe us any money. Your baggage started a long time ago, 2002 and 2000. And it's like having a giant millstone around your neck. You get a DUI, you get another one, you get revoked. Then you're stuck. Even though it was 26 years ago, the Driver License Appeal Division is very limited in granting people restricted licenses. Then you keep driving, which just piles on the further suspension. So you're revoked. All right. Do you understand that by pleading to this, you're giving up all the rights in this advice of rights?
Yeah.
You won't be having a trial and you won't have all the rights to go with that.
Yeah, I understand. Can I say something?
Yes.
I did recently inquire about a class they offered called a Road to Recovery, I believe it is.
Yes.
They gave me my driving record, and I know now what I have to pay on, to get it taken care of. It is very important to me to get my license back. I'm a single parent.
Why were you driving around over here in St. Joe County?
Because a friend of mine is at the women's facility, the probation facility.
Somebody's at the probation center?
Yeah, and her parents reached out to me and asked me if I could take her some toiletries because neither one of them are able to drive around really.
So you got stopped right there by the probation center.
Pulling into it, yeah.
Why'd they pull you over?
The vehicle that I was driving was the girl's parents, and the registration was invalid, I guess.
Well, they can get in trouble for letting you drive without a valid license.
I was just trying to help them. I understand. I was making a mistake though.
Well, this is going to extend the length of your suspension. How'd you get here today?
A friend of mine dropped me off.
Where is it?
Huh?
Where's your friend?
He had to head up to Kalamazoo for a business meeting.
All right. Don't drive away from here. We'll pull you over. We'll impound your car. We'll take you to jail. I hope that 2010 white Ford isn't sitting out in our parking lot. Is it?
No, sir.
My fear is you're going to go out in the car, get in your car and drive away.
No, I'm going to be here in town for a little bit, waiting for him to come back from his meeting, but
All right.
I'm not going to be driving.
$125 fine, $125 in court costs. The fine is $250. Can you pay that today or need time to pay it?
It's $250.
Yes.
Not all of it. I probably can pay partial payment today.
I'll make it due by July 2nd. That's 30 days from today. You don't have any money that you owe us. You may owe some other courts. Anyway, don't drive around here and don't drive away from here.
Yes, sir.
All right. You're free to go.
Thank you.
All right, we are back. We have one sentence set at 11. We don't normally do sentences at 11 on a Tuesday, but this defendant is in custody and we set it for this morning. She'll be brought here shortly. We made the best use of this today. Judge Pattison just finished. I did the arraignments, which took till 9:30. From 9:30 to 11, Judge Pattison did the pre-exam conferences in this room, and now I'll use it for this sentence. Then this afternoon, we have several prelims set. It looks like several are going. Okay, this is file number 2540SD. People versus Angela Marie Richmond. Miss Richmond's from Kalamazoo. She was charged with operating while intoxicated in March of 2025, and the case has had some twists and turns since then. Let's talk about the original ticket. Defendant got arrested on January 9th of 2025 in Three Rivers. And at 131 and Super 8 across in front of Myers. The matter was also charged with refusing a preliminary breath test. The defendant entered a plea to impaired driving, and then we lost track of her. And we lost her for a number of months. Then she got arrested on May 21st, and I saw her at that time with the public defender, Mr. Stickley. At one point, she had been in Kalamazoo County, but we weren't able to get her here. She told me, or you told me on the 21st, that you got arrested in Kalamazoo on Tuesday, May 19th, and they brought you here on the 21st. Is that correct?
Your Honor, I got arrested May 19th and they brought me here May 20th.
All right, and then I saw you the next day. I think that might have been on Monday. All right, you failed to appear 4 separate times in this case, so I simply canceled your bond and set the matter for sentencing here today. So May 19th to May 31st is 11 days. Today's June 2nd. That's 13 days. Wait a minute. May 19, 10, 2 is 14 days credit, plus the day you got when you got arrested. So I believe right now there are 15 days of jail credit. Mr. Bush, what would you like me to know?
We don't have a lot of a substance abuse assessment because she wasn't able to participate in that. The initial recommendation was for 7 days. She served 15. I would ask the court to implement a sentence of time served with fines and costs.
Autumn Kiefer attempted to do a screening report way back when, and we couldn't find the defendant. And so it doesn't have much in it. It had a little bit of her background. So we lost you sometime in 2025. Miss Richmond, where have you been since then?
I moved out of Vicksburg and into Kalamazoo City and started working. Had to start finding rides because the only vehicle I was depending on, which was not mine, broke down. And I've had so much of my mail lost. I never saw any chauffeur costs in the mail or anything.
Well, you had a lawyer, Mr. Bush.
Mhm.
He's had the same phone number for 75 years. All you had to do was call him. We made several attempts to get you in here without success. In fact, we got you here, as I said, some days. This is the 4th time you failed to appear. But you went to jail. This happened in January of 25. There was a period in 2025 where you were in the Kalamazoo County Jail. You were in jail from when to when? In Kalamazoo, do you remember?
The only time I was in jail, it was only for like 24 hours.
I guess it's those 2 days jail in July of 25. All right, the facts here are bad. You were driving like so many people do, the wrong way down 131. It used to happen it still happens all the time. They rebuilt the highway a couple of years ago, but you were driving the wrong way in front of Myers. Fortunately, it was very late at night. Despite that, they did reduce it to a charge of impaired driving. I don't know what you would have recommended. You don't have any previous drinking driving convictions. Your blood alcohol is 0.179. What Autumn said in her original screening report, the officer attempted to schedule this, was unable to do so. The officer feels that a probation in this case would not be successful and waste everyone's time and the court's resources. That was in December of 25. And now here we are in June of 26. Ms. Stoll, anything else to add here?
Your Honor, I agree that maybe 15 days jail is appropriate, but I would also ask the court to put the defendant on 12 months probation just to ensure that she's staying on the right track. As the court's indicated, her BAC was very high. And the facts are bad if she was driving the wrong way down 131, a busy highway.
Well, there's some logic in that, but she doesn't live in St. Joe County. She doesn't have transportation, and she regularly fails to appear for court. My fear is if I put her on probation, I'm just setting her up for failure. You told me where you were working, and you probably lost your job as a result of being incarcerated here. And you said it again today, and it went past me. Where were you working?
I was working at Drake Dental in Portage.
Drake Dental.
I have since quit that job. I started another one hoping I could take care of everything. I just quit it on Thursday, right before all of this happened on Tuesday, and I was arrested with hopes to make it here because I can't just keep taking days off. So I quit my job to come here. And then,
And again, how did you get arrested? How did they stop you and ask you some questions about something and found this old car?
I had gotten bit by a dog and
That's
several
right.
attacked by a dog, and the police were there. Somebody said I pushed someone else, which I didn't. I was getting attacked by a dog, and they arrested me.
And it wasn't a pit bull, it was an Australian Shepherd. All right. Ms. Stoll's referral makes sense, but I'm not gonna do it. I'm not gonna chase you around. I'm gonna let you go back to Kalamazoo. The guideline score was 5 to 7 days. Autumn's recommendation was 7 days. You've actually done 15 days. I'm gonna waive the fine and costs. I'm gonna waive the screening fee because we never actually did it. I'm gonna put your police, was there a police reimbursement? Let's see. Restitution of $255 to the sheriff's department. And $150 attorney fee. At one point, I had some bond money, I think. See if I can find it. Did you pay some money to the court? Did you pay some cash money to that? I don't think I have any bond.
She doesn't recall paying.
I think I let her out and then she paid me back by not showing up again. Well, let's add that up. 125 in the mandatory costs. 150 attorney fee. 255 police reimbursement is $530. That's without any oversight, without the victim impact panel, without any fine. I'm going to make that due by October 1st. I'll make it December 1st.
Your Honor,
Yes.
I see that the PSI says that the restitution should go to St. Joseph County Sheriff's Department, but I believe 3 of us made the arrest and investigated that.
I don't know, the police report is by Officer Greenhall. And they wrote this under state statute, but you're right, we'll do it to TRPD. Thank you, Abby. Where were you going?
I had gotten lost
I was looking for a gas station that had diesel for my car because I had just gotten it.
Well, where were you headed when you got lost?
I was heading out towards 131 looking for a gas station that was open that had diesel
Where did you start?
in Vicksburg, and they didn't have any diesel pumps in Vicksburg.
Well, you were at .179. That's spooky that you made it all the way from Three Rivers from Vicksburg to Three Rivers in that condition.
Well, my phone service wasn't stopped working. So I got completely lost. And when I turned on 131 is when I realized that it was the wrong way. And then I quickly turned off. And that's when they stopped me. And I was quite scared. That really.
What kind of car did you have?
A Mercedes Benz. I had just gotten it. Didn't have the plates on, so I assumed that it probably looked pretty suspicious.
Well, yeah, going 80 miles an hour the wrong way down 131 looks pretty suspicious. They'll tend to pull you over for that. Anyway, you seem like a nice woman. You had these other issues in Kalamazoo County last summer. You had a good job. You just did 14 days, 13 days straight up. That's what you get for not showing up 4 times. I'm going to have you do a payment plan. So the clerk's going to need to talk to her about paying that fine between now and December. But I'm giving you 15 days, credit 15 days, $430 in a fine. And this will restrict your driver's license. It won't suspend it. It will restrict it to drive to and from work, treatment, court, other limited purposes.
Mhm.
All right, you're free to go.
Thank you, Your Honor.
Good luck.
Thanks. Well, I have papers like soon.
Will she get a paper?
I was gonna ask the bailiffs to hold her so the clerks can talk.
So she gets, okay, thank you.
And then it'll be due October or December.
Good afternoon, Mr. Buds.
Good afternoon, Judge Middleton.
This is file number 26704 FY, People versus Frank Leonard Butts. Mr. Butts is charged with resisting obstructing a police officer, 3 counts of assault and battery as a habitual offender. Resisting obstructing a police officer in and of itself is a felony. It's punishable by up to 2 years in prison and a fine of up to $2,000. He's charged as the 4th habitual offender, which I think would make it a 15-year maximum.
Yes, sir, it does.
What's that?
It does.
All right. And 3 counts of assault and battery. Mr. Gary Gabry is here, the chief assistant from the prosecutor's office, as well as your lawyer, Mr. John Bush. I was advised just a moment ago that you're going to enter a plea to a misdemeanor charge of attempting to resist or obstruct a police officer. That's punishable by up to a year in jail and a fine of up to $1,000. And 1 count of assault and battery. Assault and battery is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Mr. Gabriel, you confirm the plea offer?
That is correct, Your Honor.
Mr. Bush?
That is the accurate plea offer, Your Honor.
Mr. Butts, are you going to enter a plea to those 2 misdemeanor charges?
Yeah, I'd like to explain myself.
Well, once I'll take your plea, I'll let you tell me a little more.
Okay, yeah, we'll enter.
Now, I know a little bit about this because I read the bond information sheet, but so let's talk about this. By entering the plea to these misdemeanors, the felony and the supplemental portion are all going to go away. But you will be giving up your right to have a trial. I know you know all this, but I need to tell you
I know,
this.
you got to state it on the record.
Yes. There will be no trial if you enter this plea. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by a lawyer. Mr. Bush has been appointed to represent you. You could also hire a lawyer of your own choosing if you wish. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand on your own behalf and testify, but you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
All right, give me a minute to make my note here. I'm not going to do the sentence today because I want to get some more information. But all right, this started, you live kind of on a cul-de-sac, dead end kind of thing, don't you, on Lakeshore Drive?
Yeah.
And the neighbor kids were driving four-wheelers up and down the road, is that correct?
Yeah, and this wasn't the only occasion. It's been going on for, well, see, I got woke up about 1 something in the morning. I believe it was the 17th.
All right, well, let's just stick to this date. Right now, this is April 19th.
Yeah.
All right, and because of that, you got agitated, is that
I
correct?
got really agitated. Yes, I did.
All right, so, did you pick up a shovel?
Well, the first time when he went through the road, when he went through my yard, I said, okay, this is enough. Going up and down the road, 2 o'clock, 3 o'clock in the morning, something different, but they're running on my yard now. So I grabbed my shovel and I walked out to the end of my driveway, standing on my property. And this time when he went by, he went down to the end of the road to turn around. And he seen me.
What time of day or night was this?
Excuse me?
What time was this?
This was about 2:30 in the afternoon.
All right.
I couldn't do anything about them running them down the road during the day, but it was, at night was agitating me, and it had been going on for a week. And so when he ran across my yard, I thought, okay, now I got to do something about it. And I know I have the right to protect my property. So I grabbed the shovel and I went out there and stood. When he turned around, he seen me standing there with a shovel. The quad runner stalled out. He got off. I started yelling at him. You want to come up here and run through my yard again? But the shovel was still in my hand. It was on the ground. And he got off and he started backing up, took his helmet off, and I could see who it was, a young kid. And
how young?
10 years old. But I couldn't tell with the helmet on. So when he took the helmet off, then I could see how old he was. And he was backing away saying, I'm sorry. He took off and went the other way. So I know I did scare him, and I am guilty of an assault.
All right, well, you had a shovel in your hand.
I had a shovel in my hand.
All right,
but
then the cops get there, and it goes downhill from there.
Yeah.
So tell me about that.
Okay. I started screaming and yelling at him, and his parents came down. And she said, well, he's only 10 years old. And I said, yeah, but he's your responsibility. You're not being responsible for these kids. You're not even being responsible for yourself. They can't take care of the house.
Now, they're driving these up and down a public roadway, is that correct?
Well, it's a private road, and it creates a lot of dust. They do it at 2:30 in the morning.
All right, but so
deliberately.
Anyway, it's a roadway where people drive.
Yeah.
I got to figure out whether
it's a private drive.
All right.
Yeah.
So the cops got there. You're all cranked up. Now, something I was disappointed to see, it said you smelled of intoxicants.
I was pretty intoxicated that day. Yes,
I thought you'd quit drinking.
I did. I don't drink very often, but when I do, I go over the top.
And end up in jail.
No, hopefully not yet.
You did that night. So anyway, so the cop got there, and then tell me about that.
Yeah, they got there, and they came up to my front door, knocked on the door. And of course, I could see who it was. They said, we'd like to talk to me. I said, no, you don't want to talk to me. I opened the front door, and she said, well, can you come out here and talk to me? I said, no, I'm not going to come out and talk to me through the door. And then she said, well, at least tell us what's going on. Well, I'll show you. So I walked out the back door, and I showed them where they're going across my yard. And they say it's an easement. But in town, it's a terrace, and the homeowner is responsible for the terrace. If you don't, you get a ticket. So I'm responsible for that. As long as I'm responsible for that, it's my property.
All right. So you were agitated. I may have to go out there and actually look at the lay of the land here, because if this was a public road, 10-year-old kid can't legally drive a
It's a private road, but they do drive on the public road, on the paved road. They have been driving.
Well,
on,
they
but
can't, it's not lawful for.
I know, they moved 2 blocks down the street. My sister here is buying their property, the one that they.
So I'm assuming you're not the only one that's agitated by this.
Everybody in that neighborhood out there, they're a menace.
All right, well, we'll try to explore it further. But anyway, you were disrespectful to the cops. Eventually, you lost your temper.
Yeah, I apologize for that.
All right.
If I hadn't been so intoxicated, it might not ever happen.
I don't disagree with that. They tried to put the gotchas on you and you pulled away.
I don't see that in the video, but they did tell me that I needed to stop. I couldn't go in the house.
And then you walked back toward the house.
Yeah, and then he told me I was under arrest and he grabbed the whole thing.
All right, maybe I need to watch the video. So I need victim input. Police report.
As far as I'm concerned, I did hinder their investigation.
We can do the rest of it.
Okay.
Good.
All right, I'm satisfied, Mr. Gabriel, with a factual basis for.
I am too, Your Honor. There is a factual basis, Your Honor.
All right. All right, Mr. Butts, like I said, you used to be in here a lot, and then I haven't seen you in years, and you got sober and you were trying to stay out of
I
it.
own my own property now. I'm being a responsible individual. And as far as I'm concerned, I was doing everybody a favor out there that day.
Well, I don't know about that, but we'll find out. Let's pick a date where we can put this for sentence. You, Mr. Bush, and I are all about the same age. And I think Mr. Bush probably represented you in the past time or two. And I'll say, we're getting too old for this.
Yes, I am. I really am. I'm getting too familiar with it too.
We'll stop doing it.
I'm not your normal lay person anymore.
No, how about Monday, July 6th at 10:30? Does that work for you, John?
Hey, Andrea, am I free on July 6th? What time?
10:30.
10:30 in the morning? Mhm. I know I was, I didn't know if you scheduled anything, but, well, that's good. Okay, thank you. That's just fine, Your Honor.
That works. All right, Mr. Butts, we'll set this for Monday, July 6th at 10:30. You'll get a notice, stay in contact with your lawyer.
Does he need to meet with the probation officer?
No, I'm not asking for a pre-sentence.
Okay.
I'm gonna get the police report, take a look at the video. I may even go out there and eyeball this part of Lake.
I've got some photos and some videos too, but I don't know how to get them
Well,
on.
share those with your lawyer.
Yes.
Share those with Mr. Bush.
Okay. Yeah, I have already, but he's saying we need to make copies of it. I don't know how to do it.
Well, you come in, my secretary's kind of busy going
Okay,
those things, so
okay.
if you get there.
She's a magician. Huh?
All right, Mr. Butts, you're good to go. I'll see you on July 6th
Just a
at
sentence
10:30.
on July 6th. Thank you, sir.
All right, that leaves Weinberg and our joint prelim. You're doing the joint prelim, Gary?
I didn't realize you were on the phone.
We'll stop the live feed while we line up the case.
What's happening?
Todd Nolan Myers, 26F711744.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Todd Myers.
Where is Mr. Myers at?
He is in the Wayne County Jail. He's on screen. Mr. Myers, state your name.
Todd Myers?
All right, so we're just, you can't do the exam next week?
That is correct, Your Honor. I will be in the middle of a jury trial on the 9th.
Okay, so we're gonna do the preliminary exam on the 16th.
That is correct.
All right, so sir, you have the right to a probable cause conference within 14 days of the date of the arraignment. Then you have the right to a preliminary examination within 7 days of the date of the probable cause conference. Your lawyer is unavailable. She's asking me for an adjournment. I'm inclined to grant it. But that means if I do grant that, the preliminary exam will not take place within 7 days of the date of the probable cause conference. Do you understand that?
Yes.
Do you waive that right?
Yes, sir.
All right, I'll accept that waiver. We're going to set this for June 16th. At 10 o'clock, Lisa, okay?
Yes.
Your
At
Honor, can
10
we get a
a.m.
little later?
As long as you're going to show up on time. What I don't
I-
want is to set it for 11 and have you warps and, traipsing in here at 11:45. That happens all too often.
I will
can-
be there on
I-
time.
What time you want?
What you said 11?
I'll do 11 as long as you're here by 11.
Yes, sir. I'll be there by 11.
June 16th at 11. Okay,
Mi-
good enough. Have a good day. Thank
Your
you.
Honor, Mr. Myers wants me to address his bond.
Well, I got to get the prosecutor in here. Get the
Okay.
prosecutor and the officer in charge in here, will you please?
She's on
Yep.
Zoom, Judge. I'll bring her in.
Okay. The domestic third offense. Who is the prosecutor on this? Oh, Ms. Holloway, that's
Miss-
right.
yeah.
She's ill today. Good morning, Ms. Holloway. I'm sorry you're not feeling well. Your name?
Thank you. Nora Alloway on behalf of the people, P86528.
Ms. Tucker wants to address bond. I've adjourned the exam until the 16th at 11. This is with regard to Mr. Todd Myers, DV3. So go ahead, counsel.
Yes, I had a chance to speak to Mr. Myers, Your Honor. He is 38 years old. I'm not minimizing this as a DV third, but other than the misdemeanor DVs, I did not see any other prior felonies. There is no habitual on this. He does have a job. He works for LA Landscaping in Brownstown. He works 7 a to 7 p.m. He has custody of his 14-year-old son. His bond right now is $35,000, 10%. He has been in custody since he was arrested on this case, Your Honor, at this point, so he can get back to taking care of his son. School is about to be out, and him to get back to working. We're asking if he could get a personal bond with GPS tether, and work hours.
Detective Jakotka, are you on this case? If so, will you state your name?
Yes, sir. Detective Chad Jacoda, Flat Rock Police.
I'd like the two of you between you, I don't care who, to enlighten me on allegedly occurred, whether or not there's any warrants and whether or not he has any other prior convictions. You can go ahead. I don't care who talks.
Your Honor, I am looking through his criminal record as of right now. He does have prior assaultive convictions, although not felonies. He does have domestic violence convictions as well, as well as an assault and battery. I am taking a look at the report. And the allegation is that, would you like me to go in detail, or how would you prefer?
Yeah,
Just a vague
tell me,
summary?
what was it, a slap, a push, a punch? Yeah, allegedly.
It looks like that at one point he had slammed the complainant on the ground, punched her in the head, again, slammed her on the ground. This all occurred on, I'm just trying to get the exact location here. It says that it happened on somewhere in the area of Telegraph Road and Deer Creek Drive. And that the complainant allegedly told the police that he had been beating her for a long time.
Looks like he had one in 13 and in 15 and another one in 2020 that was resulted in the conviction in 22 in the Wayne County Circuit Court. Was placed on probation for 3 years on January 12th, 22. And there was another assault and battery out of Riverview. Boy, if we keep talking, I'm likely to raise this. Where does he work at?
LA Landscaping in Brownstown, Your Honor.
You said that. I'm sorry. I apologize. How much does he make there?
Mr. Myers, how much do you make?
23 an hour.
Counsel, this is no reflection on you, but I've heard enough. I'm going up to 50,000, 10%. 50,000, 10%. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to be released until fitted with a GPS tether. You're not to be within 3 miles of the victim or residence or placed in employment. No firearms, no weapons, no alcohol, no marijuana, no illegal drugs, no contact with prosecution witnesses, and no contact with the victim, Molly Fox. If I find out there's been any contact whatsoever,
Should be
that
done.
would be a serious bond violation, okay? So you're gonna have to put 5,000 to secure your release. Lisa, redo that minimus, please. Thank you very much. We'll see you, everybody, on the 16th. Have a good day. Thank you. Sorry,
We're done.
counsel,
This
but
is today.
it's not high enough in my view. Derek Dilmer Bolds. 23B 143499. Good morning. Is Mr. Bolds in there?
Yes, Your Honor.
All right, sir, your name?
Derek Bowles the second.
All right, so this is May 8 of 24 that a warrant was issued. And I've got a charge here now that alleges count 1 that you failed to attend your scheduled probation visit on April 3 of 24. That's count 1. Do you understand the charge?
Yes, Your Honor.
Count 2 that you failed to attend your scheduled probation visit on May the 7th of 24. Do you understand the charge?
Yes, Your Honor.
Count 3, you failed to pay your fines and costs as ordered. Do you understand the charge?
Yes, Your Honor.
Count 4, that you failed to submit the monthly testing as ordered on April 16 of 24 versus on-site. Do you understand the charge?
Yes, Your Honor.
Since you absconded, you could have, there's 4 technical violations, but either way, on your 4th, you could get 93 days. Also, since you absconded, you could get 93 days. If you plead guilty or if you're found guilty of any one of these charges, do you understand that?
Yes, I do, Your Honor.
All right, you have the right to a lawyer. Be happy to provide you with one at public expense if you would like one. Would you like a lawyer?
Yes, I would, Your Honor.
Enter a not guilty plea for you.
Judge,
We're gonna get
he should have spoken to the arraignment attorney already. This is a video.
Just
walked in.
Oh, I'm sorry.
I was next door to Judge Heston's church.
I'm sorry. My apologies. I didn't know you'd spoken to him. Your
I
appearance.
spoke.
Good morning, Judge Matthew Gay, here on behalf of Mr. Bowles.
So for purposes of arraignment, I'm entering a not guilty plea. I just told him that he had the right to a lawyer and you walked in. So what is he going to do on these?
Judge, I spoke to Mr. Bowles. He's explained the situation. He's gonna go ahead and plead guilty to all counts with an explanation.
All right. Get in, Jessica, in here, will you please? Is that what you want to do, sir?
Yes, Your Honor. I'm ready to get this behind me, sir.
I'm sorry?
I said, yes, Your Honor. I'm ready to get all this past me.
If you plead guilty here, again, you could get 93 days. Do you understand that?
Yes, I do, Your Honor. Yes.
And to the charge that you fit, and you understand all your rights.
Yes, I do, Your Honor.
To the charge you failed to attend your scheduled probation visit on April 23 of 24. How do you plead?
Guilty.
Failed to attend on that date? Sir?
I can't hear you, sir.
Did you fail to attend your probation visit on that date?
Yes, I did, Your Honor.
Count 2 that you failed to attend your probation visit on May 7 of 24. How do you plead?
Guilty, Your Honor.
Did you fail to attend on that date?
Yes, I did, Your Honor.
Count 3 that you failed to pay your fines and costs balance owing at the time as of May 8 of 24 of $773. How do you plead to that?
Guilty as well, Your
You
Honor.
failed to do that?
Yes, I had.
Count 4 that you failed to submit the monthly testing as ordered on April 16th of 24. How do you plead to that?
Guilty, Your Honor.
You failed to submit the testing as ordered on April 16th of 24.
Yes.
Anybody force you to plead guilty?
No, they have not, Your Honor.
Please are accepted to those 3 counts. That's where we are with it. And, or those 4 counts, I should say. Your name? Anything you'd like to say on his behalf? I mean, where's he been?
Judge, he's a commercial, and at the time he was working out of state in North Carolina. I believe he did let the court know, and he was flying back and forth between Michigan and North Carolina at the time of this attended court visit.
He didn't let the court know that. He never sought consent of the court for that.
He did, when I spoke, and he did not, he did tell us, he did let the court know that he was.
Well, that's not true. Did he ever let you know?
As far, I don't have anything in the file, does
I haven't. Nothing. Nothing. That's just embellishment or a lie. Go ahead.
No.
What else?
I did.
No, you didn't.
I was already down. Yes, I did, Your Honor.
Did you come and talk to me?
I believe it was during one of our actual dates. Yes.
Anything? Any indication? Hang on a second. Any indication in there, Lisa, that I gave him permission to leave the state?
Let me read through the notes real quick.
Take your time. He didn't tell you, right?
As far as I have nothing in the file that says he did, I'm also looking at a screening assessment, and he reported that he worked as a journeyman for Royal Cooking Company for the last 15 years. Nothing in there states that he traveled into that.
I'm looking at the bond sheet.
I don't see anything, Judge.
Either. He's not telling the truth. He must have been confusing me with some other judge in some other court in some other state. Go ahead. What else?
Just as far as the balance, there was a portion that was paid down, I believe it was $495 that was garnished from his tax return. Recently, I believe that was in April of this year. Other than that, Judge, Mr. Bowles has indicated to me that just the difficulty of traveling back and forth with him being out of state and with some other family obligations that were ongoing at the time. He did not complete anything else with regard to his.
He lived in Taylor. You still live in Taylor?
Yes, I do, Your Honor.
Oh, come on. And then you tell your lawyer a lie and ask him to come in and promote it to me. Come on.
I did not lie to. I was in North Carolina during these times. I was flying back and forth. TSA did hold me up, and I missed my initial court date with you guys.
You could not leave the state without the consent of the court. That's what I told you. You never asked to go anywhere. You're not being truthful.
No, I was already.
You never asked me to go anywhere. You didn't show up here before the court case was resolved either. You didn't show up on August 30th, 23. Then you didn't show up again on May 29 to 24. I mean,
my apologies, John.
Well, don't apologize to me. I'm not serving the jail time. You made a decision and it's not going to work out well for you. Anything?
He never completed.
I know.
Him at least one time for his instructional. We went over everything. He never completed the alcohol education level 1 class. Didn't complete the victims impact panel. 16 hours of community service was never completed. And we're past 2 years at this point. He was sentenced to probation back in March 13th of 2024. So we've hit our 2 years at this point.
How much does he owe, Lisa?
Let me check. $492.
Is there any other way we can resolve this by chance, Your Honor?
How many days credit does he have? Just when was he picked up on that, detective? Can you identify yourself and tell me when he was picked up?
Detective Claff, Browntown Township Police Department. Your Honor, he was just picked up from Southgate Police Department. Would have been at yesterday, Your Honor, at 11:45 is the time on the sheet. June 1st.
We've got to give him 1 day credit for this case. How that?
Anything else?
Just that he's full-time employed, he's been with his company for 18 years. He does have a 16-year-old child that he's financially responsible for, Judge. Since that time, he hasn't gotten into any other trouble, any other issues since this last conviction. And he did indicate that if he does go to jail for an extended period of time, he will lose it.
Anything else you'd like to say, sir?
No, Your Honor. I do apologize.
Don't.
I'm ready to put this behind me.
You don't need to apologize to me. Like I said, I'm not doing the jail time. You can't do this. There's nothing There's nothing that troubles me more when somebody doesn't give it a chance. You didn't give it a chance. You just decided you were too big and bright or whatever, too important to do what I wanted you to do. And now you got to pay a price. And it's unfortunate. I didn't want to send you to jail on this. If I wanted to send you to jail, I would have done it the first time. But now you leave me with no choice. You didn't do anything. It's 2 years later. Your probation's revoked. You're to pay costs of $550 and serve 93 days, credit 2 for 91. If you pay costs of $550, I will suspend 47 of the 92, requiring you to only serve 45 days in jail. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. So if you pay $550, you'll be out in 45. If you don't, you're going to serve 91. I wish you well. Thank you very much. Good luck. People against Griffer. Ryan Joseph Griffer, 26B-711-925.
Good morning, Charge and Staff. John Graziani, on behalf of Ryan Griffer, who is approaching to my left. Please identify yourself, sir. Ryan Joseph Griffer.
Ms. Alloway, your name?
Morning, Your Honor, Nora Alloway on behalf of the people, PA 6528.
So we're adjourning this?
Judge, we're adjourning it. However, I just want to bring to your attention that this is their home and Mr. Griffer wanted to make contact with the children. I indicated that my kids.
Hang on a second. Just wait a second.
The victim's on Zoom, Judge.
What's that?
The victim is on Zoom.
Okay, have her come in here. Let's just figure out the date we're going to do this. Are we doing this in 2 weeks?
Judge, I'd like, because of the, the urgency of the situation, I would like to do it in a week, if that's okay with,
That's fine. We'll set it for June 9th at what time, Lisa?
For
10 o'clock.
That's fine.
10 o'clock?
Yes.
Okay. 10
Your
o'clock.
Honor, if I may, just for the record, is the complainant on Zoom?
She is.
Right there.
Your name,
yeah.
ma'am? Ms. Michaels, I need your name. Yep. There you go.
Jennifer Michaels.
Okay. All right. So what did you want to bring up bond wise? We're adjourning this till next week, June the 9th at 10, ma'am. Who wants to bring up what?
Judge, I'm asking for a personal bond. Mr. Griffer has never been in trouble.
He's got a personal bond. That was already given.
Okay, I want to continue that, Judge. I haven't read as well as I should on this.
You're fine. May 10th, May 24th. I don't know if that's a magistrate. Somebody gave him a $10,000 personal bond out county with do not use alcohol, do not possess or purchase a firearm, no contact with Jennifer Louise Michaels, don't enter 15748 Milliman in Brownstown. May go to the address once accompanied by a police officer to remove personal belongings. So what's the issue?
The issue, Judge, is that go ahead.
I apologize. I just wanted to make a note for the record. I did speak to the complainant in this matter. She did advise that she's received almost 80 phone calls in the last week, all anonymous, but that she has an app that reveals the number that is anonymously calling her, and it has revealed that it is the defendant. Now, I did ask her for those screenshots. I just want to put the court on notice that once I receive those screenshots, it's possible I may ask for a bond hearing.
He wouldn't do that.
You know what, Judge? Because he's adamant. How do you respond?
I don't want him to respond with anyway. I'm just telling you, if I find out you called once, bring about at least 10,000 in cash with you next week. Okay? You got it? You
Judge,
understand? Wait, answer me.
Judge, if I
wait. I want to make sure we understand one another about this. This judge ordered no contact or magistrate. That means no contact. That means you can't write her, see her, text her, email her, drive anywhere near her house. Do you understand? Do you understand if you continue to do that, if you did that?
I did message her.
Well, you just incriminated yourself. Now I'm raising the bond now.
Judge, you've been responding.
I'm raising the bond now. How many times did he message you, ma'am?
I received about 80 anonymous calls from him.
Where does he work?
He's an operating engineer, Judge.
Good, he's got a lot of money.
Judge, if I can respond, this has been going back and forth. The alleged victim had contacted Mr. Griffer.
That's not a violation of her bond.
Judge, in fact, when he was being arrested, he was contacted.
That's not true.
Wait a minute. Wait.
What?
Just please listen to me, ma'am. Don't say anything.
Okay.
Since May 24th, have you contacted him?
I responded to one message that he sent me the day he got out of jail. And I said, I don't want anyone contacting me.
All right, counsel.
Judge, I'm asking.
I can either have a hearing now, or I'm gonna set a bond now, but he's not walking out of here with a personal bond.
Judge, I would request a hearing in the near future.
Let's do it now. He just admitted that he violated the no contact.
Judge, I think what's happened is he's not had the opportunity to stay in touch with the children. He panicked. He needs to get the clothing. He's never been in this situation. And in fact, if anyone had been arrested.
Period. That's what I'm doing. You have to post 2,000 to secure your release. And if I find out you did it again, sir, it's going to be 20,000 cash. And if I find out you do it again after I said 20,000 cash, it's going to be 200,000 cash. Do we understand one another fully and completely?
Yes.
Maybe the magistrate or judge that set the bond didn't make it clear. I expect you to follow it. Do we understand one another?
This is the.
This is. Got it. Is this one? No,
I'm sorry?
this one's.
No, I did not give you that one to you.
Okay.
I will.
Court does call the case of NKSK Properties LLC versus Ashley Peters.
Good morning, Your Honor. My name is Noel Saul, appearing on behalf of the plaintiff NKSK Properties.
Oh, right. Ashley Peterson, Brian Riggs, Asia Funderberg. They were not present. Would you like to take a default, sir?
Yes, Your Honor, I would.
All right. Raise your right hand.
I have a little problem with my.
Okay,
That's as good as it gets.
That's
as good as it
firm.
gets.
All right, sir. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, go ahead, sir.
Your Honor, rent is due and owing in this matter for March of $1,000, April and May at $3,000 each. That's $7,000. There's a water bill in the amount of $1,119. Unfortunately, when the tenant left, she left the property in extremely bad shape with trash, food in the refrigerator, rotten food in the refrigerator, because she had cut the electricity off 2 weeks before she turned the keys over to my clients. There was a $6,350 cleanup bill. $6,350. It required 4 dumpsters to clean up the trash that was left in the house.
Okay.
And I have the bill from Nash and Brothers.
Can I?
Yes, Your Honor. In addition to the trash that was left, there was damage, significant damage to the property in terms of broken windows in front, damaged holes in the drywall. And there was an additional $9,000 bill that was services provided by S3 Paint Solutions.
$9,000 bill?
Yes, Ron.
All of this work was done or needs to be done?
All of it was done, Your Honor. It was completed, I think, 2 days ago.
How long were these tenants in the unit?
They moved in August of 25, Your Honor.
did all this damage?
John, there were 3 tenants that we know of. When 2 of the tenants moved out, there was another person who was living there who was never, we don't know who that person was. We only know that when the landlord went to collect March rent on March 20th, he answered the door because Miss person wasn't there. And I believe, unfortunately, all of these were reasonable and necessary repairs. These were the first tenants in this property. It had been, literally, it had just been acquired by the landlord. This is the property itself. It's single family brick structure in Solani. Carpet had been put in, it had been recent, it had been painted, everything was fresh when they were coming in as the first tenants to the property. And I have miscellaneous photos of the state of the property when they were able to get possession.
Okay.
I understand the amounts sound significant, and that's why.
But looking over the bills and them not being here, and they knew this is date and time set for trial, and then a money
I'm sorry, Your Honor, this is a settlement conference. I had not brought them to be here to explain those bills.
Pardon?
This is a settlement conference, and for that reason, I had not requested the persons who issued those bills.
No, I understand that. I guess I said it. Defendants here.
That's correct. The defendants are not here.
So when I total everything that you've given me, and about 931 away from my jurisdictional limit, I get a total amount of 2469.
Is
that what you get?
Yep.
Okay. Now we're going judgment to the plaintiff. Do you have who showed up?
That was Ashley Peterson, Your Honor.
I think Ashley was the only one that showed up.
She was the only one who appeared. That's correct.
All right. Judgment to the plaintiff for possession. Said that's necessary, but I have your cost in this case, counsel. I have 130 filing. I have 94.35, $75 attorney fee. It's going to be 35. 9. Well, I have 209.35 in cost. So I will grant a judgment to the plaintiff for $24,069 plus $209.35 in cost, whatever that total out to be. That'll be the redemption amount, as well as a money judgment in that amount as to defendant 1 only. Right. Defendants 2 and 3 were served by attachment, so I can't issue a money judgment. So the money judgment will apply as defendant 1 with a writ to issue in 10 days, should that be necessary. Right. Thank.
Do I need to present an order to the court on this?
Yes, I need a judgment.
Okay.
All right. Thank you. Do I dare call this one? I will. Court calls the case Fixing Housing 401k Plan LLC versus Erica and Aaron Ward.
I'm Erica.
You can come up to the here. Okay. This is your motion for the court for reconsideration of the calculation. Have you heard anything from the other side? No.
No, and I did also submit a request for my security deposit to him. I haven't heard anything back on that, 7,500. He also did not show up for the circuit course mediation, the circuit court, the other one. And he's just disappeared.
I have nothing further.
From what I understand, so the record's clear, you heard from the plaintiff, well, the owner sent an email asking if the court had considered his previous email. You responded saying you had gotten nothing from him. Is that correct?
Correct. I responded that I did not have an email to respond to.
When you sent that response, did we receive a response at all?
No, sir. I sent that response that's now.
And haven't heard anything. Then I'm going to make this quick. I think my initial calculations are correct. I looked back, but then you supplied this documentation. I will reconsider the amount. And so I will adjust the damage award from $22,566.04 to $19,057.08. And then I will grant your request. The court finding circumstances would justify that. Consider you had to shut down your equine business. Permitting you to pay $3,176.18 for 6 months. Given that we are on June 2nd, and I realize you filed this whenever, I will begin that July 1st, 2026. And then the corresponding final payment would be due 6 months from that date.
And then
December 1st.
And do I send that to him directly?
Then what?
The payment? Or do I send it to the court?
When you send stuff, does he receive it?
Well, in the past, I used to do direct deposit. I would go to his bank and just deposit it in his account. I don't know if that account still exists. So I don't know. I would hope I'm sure he is there to get his money at some point.
So how are you intending on sending it?
Well, I would send it to the address that he's given me in the past. I can send it certified to make sure it gets there.
Why don't you do that? Because I'd rather not use the court escrow if we don't have to.
Okay.
Send it to him and keep track of the payments that you send.
Okay. So 2 more just quick questions. That 19,057.08. Now I have to think back whether when I proposed my payment plan to you, I shouldn't have to ask you this, but did I base it off the 1957.08?
I don't know.
Well, we just need to make sure that when it gets documented.
What we can do. I've adjusted it to $19,057 or $19,057.08.
Yep.
Divide that by 6. Start your payments July 1.
Okay. I'm just going to do that.
All right.
And that will be somewhere documented and sent to me. So.
Well, you prepare an order.
Oh, for you to sign that this is what was decided.
That's what I decided.
Okay.
Prepare an order for the courts.
A motion.
An order.
An order. Okay. I'll have to Google that. Okay. Just saying this is what was said. Okay. And the last question.
But the court is ordered. Yes.
There's nothing you can do about my $7,500 that I'm never going to see from him. Because
security.
Yeah. You just had that whole conversation. I was like, wait a minute. What about my security deposit? What? You were going to trying to get theirs for them.
I wasn't doing anything but my job, but
You can't do anything.
security, I can't, you can raise a claim for the security.
With you. Okay.
Certainly will come back here. I don't want to give you legal advice, so you may want to talk to someone. The security deposit, certainly there would be circumstances in which either the security deposit or double the security deposit can be deducted from this amount.
That's what I was hoping you could do, because you get to decide everything.
What?
You told them the one time that you could file the eviction based on law, but the retribution was up to you. I remember you saying that.
Yeah.
You did say all that. So technically you could.
Why are you
thank you.
on with her? Right?
You could technically take the $7,500 off of what I owe him. And that is the only way it would be fair, because he is never going to give me a penny. He's a con artist.
That's not in your, so I'll do this. In your order, indicate that the court will give a credit for the security deposit not returned against this amount.
Perfect.
So what you're going to do is you're going to take the 19,000, deduct the security, then divide 6 payments. Okay.
Thank you so much. I appreciate that.
Welcome. Probably the only thing.
Okay.
All right.
Okay.
Folks, I'm going to take now, I was going to be 10 minutes, but Ms. Ward took up part of my time. So 15 minutes, just give me 15 minutes and I'll come back and I'll figure out who I'm hearing next. All right, folks. Oh, don't look down. Huh? Oh, I'm sorry. I thought I hurt his feelings. I didn't mean to do that. Court is staying in recess. You can remain, sir.
Good morning, sir. Jesse Griffin. And this is cause number 25 DCCR 1397. Mr. Griffin is charged with aggravated assault with a deadly weapon. I'm going to take judicial notice of the court's file. Looks like Mr. Griffin was evaluated for competency to stand trial. I've received that report from Dr. Capon dated April 15th of 2026 with the finding that Mr. Griffin is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
All right, then I am going to find at this time Mr. Griffin is competent to stand trial. And what is the announcement? No.
Yes.
Your Honor, he still would like to proceed to a jury trial.
All right, so it looks like there was a plea bargain rejection in January where the offer was for 8 years. Is there any change in that offer or negotiations?
No, Your Honor.
So, Mr. Griffin, you still want to reject that and have your case set for trial?
Yes, ma'am.
All right, we'll get you moved to the trial docket. Ms. Coffin will begin preparation for trial. I do want to make sure you understand that after today, I will not accept this plea agreement unless some new information that comes to light that the attorneys don't know. If you change your mind later, want to enter a plea of guilty, it could be open to the court or to some different plea agreement, but not this. You understand?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Your Honor.
Yes, ma'am. All right, so you're Jesse Griffin. And Ms. Coffin, will your client waive the formal reading of the indictment?
Yes, Your Honor, he will.
Mr. Griffin, in cause number 25 DCCR 1397, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from August 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Coffin?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Griffin is not other than what we've already gone through?
No, Your Honor.
All right, so I'm going to find at this time that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Yes, ma'am. Jaden Simon, Mr. LeBlanc. Jaden Simon.
You know, go thing. Hold on. What thing it is?
The one that I.
Yeah.
Mhm.
Want to make sure.
Did I miss something?
I guess it's
Give it
this
some context.
Well, just, yeah, and then looking at the number, I guess there's a reason for.
He's accepting responsibility. Judy.
That's good. I appreciate that. No. All right, sir, you're Jaden Simon.
Yeah.
And will your client waive the formal reading of the indictment in each case, Mr. LeBlanc?
Yes, Your Honor. Y'all, it's helpful. That should be,
Yeah, and can you,
I'll tell you when I do.
need 2 of them. If you'll do one for each case, and then you can email that stuff later. You can get it done as soon as we're done.
Yes, sir.
And so, Mr. Simon, in cause number 25 DCCR 1760, you're charged with a first-degree felony offense of aggravated robbery. I'm sorry. Oh, I pulled up the wrong one. Let me start with this one. In cause number 25 DCCR 0918, you're charged with a second-degree felony offense of robbery. And that's from June 12th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Answer out loud for the court reporter.
Yes, ma'am. I apologize.
That's okay. And then in cause number 25 DCCR 1760, you're charged in that case with the first degree felony offense of aggravated robbery from October 10th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In both of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. LeBlanc?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Simon is not competent?
None of them were.
All right, sir, I'm going to find in each case that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. In cause number 25 DCCR 1760, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. You'll receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 25 DCCR 0918 also finds sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you in each case the trial court certifications that shows that these were agreements that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. LeBlanc. All right. Good luck to you, sir.
I got a question.
Yes, sir.
I was trying to see will I be able to get 35% on I forgot what it was called, 35% on like
So whatever happens in prison is up to the prison authorities and parole. It's up to them. It's not up to me. So if whatever's available, you would get it typically as long as you're doing well. So what you need to do, you're so young. And I know this is a long time, but it'll go by probably quicker than you think. And you're going to still be young when you get out of prison. There are things you can do in prison to actually better your life, that you can learn a trade so that when you get out, you can have a job. But they're not going to make you do anything. It's going to be up to you to search that out, be doing right so that you can take advantage of those opportunities. You don't have to be a career criminal. You can change your life. Okay. It's totally up to you. And I hope you do. All right. Good luck to you, sir. Victor Perez, Mr. Parker.
Not doing number 2.
Will Banning count to your honor?
Good morning, sir. Are you Victor Perez?
Yes.
And Mr. Parker, will your client waive a formal reading of the motion?
It will.
Mr. Perez, in cause number 17-26788, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 8th of 2018 for the third-degree felony offense of assault on a public servant. And that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation in count 1 by committing the new offense of driving while intoxicated November 22nd, 2025 in Hidalgo County, Texas. And is that true or not true?
True.
And then the state's going to abandon 2, correct?
Yes, Your Honor.
Count 3 alleges that you were at a location other than your residence November 22nd of 2025 at approximately 2:08 a.m. And is that true or not true?
True.
Count 4 alleges that you failed to report for the administrative hearing on October 6th of 2025. And is that true or not true?
True.
Count 5 alleges that you failed to report by mail or online to the Jefferson County Probation Department for February, March, May, June, August, September, October, November, and December of 2022, January through December of 2023, January, March, June, July, August, September, October, and December of 2024, and then January through December of 2025. And is that true or not true?
True.
We can drop their many counts.
All right, sir, did you enter your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes.
Do you fully understand that?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Perez is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the lesser offense of the 3rd-degree felony assault on a public servant. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir. You can go back with the bailiff.
All right, and that leaves Rob Kessler versus Dolly Hoisington. It's number 1 on our docket. All right. Mr. Kessler, I did not see proof of service filed with the court, but I do see Ms. Hoisington present. So were you able to serve her?
Obviously, if she got the court date.
Well, there are other ways that people can find out court dates, sir. Please,
Well,
a reminder that this is a courtroom. Please
and,
act accordingly.
Yes, Your Honor, I did. I dropped the one off at the courthouse. I had sent certified mail, did the proper procedures. I have the certified mail receipt. She obviously got it, so she's here at the court date. Yes, Your Honor.
Did you file it? Did you? I'm just not showing it in our files. Has it been submitted? Proof of service?
Yes, it was. Yes, it was.
When?
When I got this court date, and you amended it, and we started the process. That's how we got here. I did it. I went down and filed the papers, dropped you off the evidence, all the forms, and that's how you sent me the court date. And that's how we got where we're at now. I didn't just. That's how, I did it by filing the right papers, and
Sir,
here we are, I guess.
Correct. But so you filed what we have in our court file, and this is, again,
Okay.
all I have in front of me. I have the original small claim that was filed, that we did not have valid proof of service, and Ms. Hoisington, I don't believe, was present at that time. Oh no, you were not present at that time, but Ms. Hoisington was. You did not have good service. The call kept dropping. You plan to file an amended claim. You were informed that you have 30 days to file the amended claim, which you did file the amended claim on. Come on, load. Okay. It was May 5th. And you're saying you filed the proof of service on that date?
I'm not sure. I've had so many different, but everything I've done it right after I'm not sure the court date, but the date exactly, but I know I did it. I know that's how we got here. I don't see any other way we could have even got here if I didn't do the papers and do all this stuff. So I just don't understand. I just, I don't know. It just seems like you're just really against me in every way, ma'am.
I have to find that valid, sir. This is for every single case that comes before me. I have to find out a valid proof. Sir, please, I have let you spoke. Sir, it comes first, has to prove service. Not showing one in courts. We are here today. It happens sometimes where if you have filed it, it may not have made it into the court file. That's fine. However, I'm not showing it right now. We can set the dates and we can go from there. However,
I'll just start over. I'll just redo it.
You don't need to start over, Mr. Kessler. If you would let me finish my sentence, you would hear me say
Okay.
that I just
Yes,
need
ma'am.
you to file proof of service prior to the trial date. So
Okay.
does that make sense? So the piece of paper, so there's a piece of paper that says proof of service. There's 3 different options on it. Personal service, substitute service, service by certified mail. If you did certified mail, you would then have to provide the receipt and the little ticket they give you for the certified mail.
Yeah.
Did you file
I
that
don't
piece of
know
paper
if-
with the proof of service?
I don't know if that one, if I just sent certified mail, some I did, some I didn't. Some I sent certified mail, some you know, seemed like she was ready to go to court. You know, she seems to have got it. She's here, you know, for the court. So that's how she got the court date.
I understand.
Was a certified mail thing.
Mr. Kessler.
So that's the only way I did it, was certified mail.
That's okay. Somebody can serve somebody with notice. What I am saying is the court requires the proof of that service filed with the court.
Mm-hmm.
So she may have received a service. She may have received the claim. Obviously she did if she's here. But I need the proof of service filed with the court, just like every single other person.
Yeah, well, I don't know if I'm going to be able to get that because the proof's kind of in the pudding where she's here, obviously, but
there is no pudding proof in this court.
So I guess I have to call the courthouse to make sure that she got it, and then bring you guys something.
No,
I mean the post.
There's a piece when you file something, you're supposed to submit the proof of service. There's a piece of paper that has 3 different options. It sounds like you've done this a few times. I know you've done this a few times. I know
but
you
some
know
of
what
them I
paperwork
did-
to fill out.
Some of them I just did straight certified mail, and some I did the guys at the post office. Sometimes they would do it one way. I didn't, and sometimes I would tell them, but they would just I don't know. They would just take off and just say, "Well, this is fine. This is cheaper. Or this will be fine," or whatever.
Yes,
And,
I understand
I
that,
did
but
it like
the
3
post
different
office
ways.
does not, you are required to provide the proof of service. They give you the little ticket that you've attached to it, but you are required to file the proof of service.
Okay, I'll see
We
if I
can
can
set
track
the
that
dates.
down.
We can set the dates, but that is the court is requiring you to file that prior to the trial date.
I think I would rather almost start over because I just have a feeling, you know, after the last case, I don't know. I just feel like I could show the complete evidence, and you're probably still going to tell me it's not good enough. You know, I'm just really. I like to see the last court. I seemed like I had clear proof and evidence and everything.
Sir,
and you
we're
just
not
told me my case-
relitigating the prior small claim.
I know, but that just like I'm just like it. I just
There
seem
are
like I'm
different
at a really
remedies that you can
disadvantage.
pursue. That's fine. We're
Okay, I'm
here
gonna
purely
try to
for a
do that.
procedural. Mr. Kessler, please. Please stop interrupting the court. All right, Ms. Hoisington. Are you aware of the claim that Mr. Kessler is bringing against you for $10,000?
I got two of the papers.
And
I
what
was-
did you receive? 1 second, let's see. Why is this? Hold on, my system is very slow. 1 moment. There we go. Laserfish is not helping me out here. Come on. There we go. Okay. So we had the small claim and then we had the amended small claim. Both had $10,000 listed. Did you receive both of those or just?
I have copies of both of them.
Okay.
I
All
was
right.
never served them, but I have copies of both of them.
How did you receive copies of both of them?
The first thing that I got, the thing that is the original one that he sent was certified mail, because I always keep everything.
Sure.
And the other one, he just mailed it. No certified, no nothing.
So the one that was the second that was filed March 16th. Hold on a second. Let me make sure I get the. So there's March 16th that was filed, and then there
March
was
5th.
May 5th.
And the other one doesn't have a file date on it that he sent me certified.
So which one do you have?
I have each one. I have one.
March
I have the one
16th
that
and May
was the
5th?
original one. It says May 5th courthouse.
Okay.
And then the other one is stamped May 5th.
Okay. So it sound and do both say amended on the top?
One says amended.
Okay.
The other one does not.
Okay. So it looks like the original one was not served, and then the one that was May 5th was sent via certified mail?
I think I got all this in one envelope.
Okay. All right. So, Mr. Kessler, it does appear that you sent that certified mail, so I just need the proof of service filed with that prior to the trial date. We are going to set 3 dates. All right. Our trial date is going to be August 25th at 1:30 p.m.
And what day of the week is that?
It's always going to be on a Tuesday.
Okay, August 20. Okay.
All right. All right, Mr. Kessler, can you press *6 to unmute? Okay, and did
Yes,
you hear
I
the
do.
trial date, August 25th at 1:30 p.m.?
August 25th at 1:30.
Correct. I'm going to give you 2 other dates on top of that as well. So August 11th will be the deadline for the parties to submit exhibits. Please submit 2 identical copies of exhibits, one for the opposing party and one for the court. Any exhibits filed after the 11th may not be considered by the court, so please keep that in mind. And then August 18th will be the date that the exhibits are going to be made available for the parties to pick up. So we have August 11th, August 18th, and August 25th. The 25th will be in this courtroom, courtroom 8. And Mr. Kessler, I know that you have struggled with the video and wanting to be on video, so hopefully we can.
I'm afraid if you want to get more information than that about that particular case, you might have to pull the video file. I mean, not the video file. What am I trying to say? The court file. I don't remember the last case. I know we saw it. Or go watch, Old Squishy Gardner has a full backlog of cases for that specific one. I believe in his most recent coverage of that case, he might even have links to his previous coverage. I want to check that out. Old Squishy Gardner is a great place. You know, he's the OG. We all owe it to Old Squishy Gardner in a way, especially me. Gotta love the guy. And I tell you who else I gotta love. As a matter of fact, let me just go ahead and show you. I got a lot of names right here. Most especially Windy Creek. Your next 25. Thank you so very much. All of you people. Thank you all. Participants tonight. Everybody who's been hanging out with us. That's right, Felix OSG is the GOAT. He's been around forever. Good to see you, Donald. Good to see you, Natasha. Good to see you, Jay Ferry. It's been fun. Thank you so very much. It's been a pleasure. It's been a blast. Chat's been awesome. Robert Malone, great to see you again, by the way. Allie from Tennessee, always great to see you. Full Metal. How you doing, buddy? Mama, call you in a few minutes. Make sure everything's kosher before bedtime. Because that's what I gotta do. Ladies and gentlemen, it's been a wonderful show. Thank you so very much for hanging out with me tonight. I do want to say thank you. I think the puppies are, no, they're not. One's over there and one's down there. What can you do? Thank you guys for coming out. We do this every single night of the week where we have these little get-togethers where we watch court cases that happened that very same day. All the stuff you saw here tonight happened earlier today, unless you're watching it later on, and then, you know, check the date stamp. Whatever day it was released is the day earlier. This is, I said at the beginning, June 2nd, 2026. This is the court gallery. Ladies and gentlemen, come on by and hang out with us tomorrow night, and the next night, and the next night, and every night after. I don't foresee any time when the court will stop, so I will be here. Thank you for hitting the like button, the subscribe button, and make sure you hit that little bell too. I think that may actually have some, you know, they've been messing around with the algorithm and stuff here. I think it needs a tweak, tune up, something like that. Unsubscribe, subscribe, I don't know, but just whatever. Yeah. Thank you all so very much. You are all so wonderful. I'm your local Fusel. I am Pete. It's been a pleasure to bring you these cases. There's a lot more where that came from, even from today. We'll all watch it together later. Now, I am out. I did have something I wanted to say. Something I was thinking about. What was it? I feel like it had something to do with one of the last couple of cases there. I don't know. You know, I brought you all that. I brought you the West because we haven't seen West in forever, and she is such a great judge, and she puts them in jail. Oh my Lord! When she gives a sentence, she gives a sentence. Let's put a period on that thing. You know what I mean? That sounded wrong. Let's not end with that. I. But Judge Dad. Oh, Judge Simpson. Can't believe how upset all you got with Judge Simpson, and I actually can't believe what he did in that situation ever. He did I catch that correctly? Did he give her a $7,500 discount on whatever she had to pay old boy back because she felt that she was owed that with her security deposit? Is that kind of what I heard? I think that's what I heard, and that was kind of crazy too. Huh. You don't see that every day. Surprising. All right, we'll see what happens tomorrow. Maybe it won't be as crazy as it was today. You know what? Fat chance. Oh. Bye.